Have you ever wondered if the independent children's lawyer, or ICL, can give legal advice to one party in a case? This intriguing question arises in the intricate realm of family law, particularly concerning the ICL's role. Let's dive into the Family Law Act 1975 to find out. Under the Family Law Act 1975, the role and obligations of the independent children's lawyer, or ICL, are clearly defined. Sections 68L and 68LA of the Act outline these obligations, emphasizing that the ICL's primary role is to represent the best interests of the child. Central to this role is the duty to remain impartial in dealings with the parties involved. That means the ICL cannot act as a legal representative for either party in the proceedings. Now, if an ICL were to provide legal advice to one party, it could be interpreted as a breach of their duty to remain impartial. Remember, the ICL is tasked with advocating for the best interests of the child, not the interests of the parents. So what happens if an ICL goes against this and provides legal advice to one party? Let's delve deeper into the possible implications and recourse in the next scene. If an independent children's lawyer has indeed provided legal advice to one party, it could be considered a breach of duty. This act may be perceived as bias, as the ICL's main role is to represent the best interests of the child, not the interests of either parent. Such behavior could potentially undermine the impartiality that's crucial for the ICL's function. What can you do in such a situation? You have options. You might consider bringing this issue before the court handling your case, filing a formal complaint about the ICL's conduct, or even seeking their removal from your case on grounds of bias. However, before you take any steps, it's crucial to seek legal advice, as every case is unique. Ever wondered about the role of an independent children's lawyer in family law cases? Let's dive in. An independent children's lawyer, or ICL, as outlined in Section 68LA of the Family Law Act 1975, has a unique responsibility. They are tasked with forming an independent view of what's in the child's best interests and ensuring this view is fully put before the court. They remain impartial and do not act on instructions from any party. So in essence, an ICL is the voice of the child's best interest in court, not a traditional legal representative. But what happens when an independent children's lawyer breaches their duty by providing legal advice to one party? Let's take a look at a recent case, Morella and Morella. In this case, it was determined that providing legal advice could indeed be a breach of an ICL's duty, as it could compromise their impartiality. The implications can be serious, potentially skewing the outcome of the case and not serving the best interests of the child. As seen in the Morella case, an ICL's breach of duty can have serious implications on the outcome of a case. Now let's say an ICL has indeed provided such advice. What can be done about it? Well, the court itself has some powers to address this. Under Section 68LA 5 of the Family Law Act 1975, the court can limit or even end the involvement of an ICL in a proceeding if it believes they haven't properly carried out their obligations. This could include providing legal advice to one party, which could potentially compromise their impartiality. But what if you're not satisfied with the court's intervention? There's another option. You can apply for the removal of an ICL under Section 68N(1)(a) of the Family Law Act. This is possible if there are reasonable grounds for believing that the ICL has failed to fulfill their obligations. This could be a viable route if you believe the ICL has breached their duty by providing legal advice to one party, without considering all available evidence or potential harm caused by limiting contact with a parent. In conclusion, while the role of an ICL is crucial in family law cases, it is equally important to ensure they fulfill their obligations impartially and in the best interest of the child. If this is not the case, there are legal recourses available to correct the situation. Have you ever wondered if it's against the family law court rules if the independent children's lawyer, or ICL, gives legal advice to one party in a case? This question takes us into the labyrinth of family law, specifically the ICL's role. Prepare to unravel the complexities of family law and the ICL's role. It's important to understand that an independent children's lawyer is obliged to act in the best interests of the child or children involved in a family law dispute. According to the Federal Circuit and Family Court of Australia rules, the ICL cannot act as a legal representative for either party. If you suspect that an ICL has given advice to one party with the intent to limit your contact with your children, this could be seen as a breach of their duty. You have the right to bring such an issue to the court's attention. Depending on the severity of the alleged breach, the court might issue a warning, reprimand, or even remove the ICL from your case. It is crucial to seek independent legal advice before taking any action. If you feel an ICL has overstepped, you have rights and options to address this. Now let's turn to the family law regulations, which also govern the ICL's conduct. These regulations underline the ICL's duty to remain impartial, not to provide legal advice to parties, and to act solely in the child's best interests. If you believe there's a breach of duty, you may apply for the ICL's removal or lodge a complaint with legal aid. However, these matters carry weight and can significantly impact your case. Remember, it's crucial to seek legal advice before taking any action. To sum up, the ICL's role is a complex one, governed by various rules and regulations. Breaches of duty by an ICL should be taken seriously, underlining the importance of seeking legal advice. Continue to question, continue to learn, and always know your rights within the realm of family law. In the case of Lloyd and Lloyd and the Child Representative, ICL, Holden CJ set the precedent for circumstances under which a court might consider discharging a separate representative, now known as an independent children's lawyer, or ICL. This could occur if there's evidence of the ICL acting against the children's interests or showing a lack of professional objectivity. If providing legal advice equates to such behavior, it could justify the removal of the ICL. The case of Howell and Carter reaffirmed that an ICL must remain impartial, but can form views about what's best for the child before all evidence is presented. However, giving legal advice crosses a line into advocating for one party's position. Should misconduct by the ICL be found, the recourse could involve reporting this to their governing legal body for potential disciplinary action. If their actions have significantly impacted your case, you might also seek legal advice about possible remedies, which could include applying to the court for the ICL's removal and replacement. Remember, these are potential remedies, and your case's specific facts need consideration. Any allegations of misconduct should be supported with evidence, and it's recommended that you seek legal advice to discuss your options further. Let's delve into an analysis to determine if an ICL providing advice to a party constitutes a breach. The IRAC analysis is a systematic approach employed to dissect and resolve legal issues effectively. This method dissects complex legal issues into 4 components: issue, rule, application, and conclusion. Now that we know what IRAC stands for, let's see how this ICL scenario stands up to the test. Let's delve into each component in detail. First up, we have the issue. This is the legal question that needs answering. In our scenario, we're wondering whether the independent children's lawyer, or ICL, has breached their duty by allegedly providing legal advice to one party, and what recourse is available if such a breach has occurred. Next, we move on to the rule. This is the law or legal principle applicable to the issue. According to the Family Law Act and case law, the ICL should be impartial and act in the best interests of the child. Now let's talk about application. This involves applying the rule to the facts of the case. If the ICL indeed provided legal advice to one party with the intent to limit your contact with your children, this could potentially be a breach of their duty. But we would need to determine whether such advice was contrary to the best interests of the child. Finally, we reach the conclusion. This is the answer to the issue based on the rule and its application. If there is evidence supporting your claim against the ICL, there may be grounds for their discharge. However, this would depend on whether such advice was contrary to the best interests of the children and whether it demonstrated a lack of professional objectivity. And that, in a nutshell, is how IRAC analysis works. So, to recap, IRAC analysis is a powerful tool for dissecting and understanding complex legal issues. It's a 4-step process: identifying the issue, understanding the rule, applying the rule to the issue, and drawing a conclusion. In our example, we dissected a potential breach of duty by an independent children's lawyer. Each component of the IRAC is crucial in creating a clear, logical, and comprehensive legal analysis. Remember, the key to a successful IRAC analysis is understanding the issue, knowing the rule, applying the rule to the issue, and coming to a logical conclusion. Thanks for watching. Take heed, this is but general information, not a substitute for legal advice. It's always wise to seek professional counsel tailored to your unique circumstances. Remember, your own legal counsel can provide guidance specific to your situation and advocate on your behalf. This analysis, grounded in general principles, should not be mistaken for legal advice. We strongly recommend consultation with a qualified family law attorney for direction that's finely tuned to your specific circumstances.